So the 8th Circuit Court of Appeals just gave the ATF another win by denying en banc review of the case challenging the ATF's frames and receivers rule. This decision, however, has just set the stage for early Supreme Court review. So let's talk about what's going on in this case. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. They have dedicated roasts for organizations like FBC and GOA, so they can file lawsuits like this one against the ATF. So if you want great coffee and you want to support the 2A cause, check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I mentioned in the intro, in this video, we're going to be discussing the Gun Owners of America and the 17-state lawsuit against the ATF and that new rule that they have against unfinished frames and receivers. The case we're going to be talking about and breaking down in this video is called Morehouse v. ATF. Recently, in this specific case, we got a decision from the 8th Circuit Court of Appeals, the en banc panel, and it wasn't good, and the prior decision of the 8th Circuit also was not good. GOA, along with multiple states, tried to get the 8th Circuit to recognize how this new ATF rule will in fact infringe on our right to keep and bear arms. And what GOA wanted was a preliminary injunction, at least to be in place to halt this rule until a full trial and full merits decision could take place. Well, recently, the 8th Circuit ruled unanimously that a preliminary injunction should not be granted because plaintiffs allegedly could not show irreparable harm, which was caused by this new rule by the ATF, this frames and receivers rule. After that decision, GOA sought an en banc panel review of that denial, but we received an order from the 8th Circuit Court of Appeals, the en banc panel, that they have denied review of this case. Because of that, this means that the frames and receivers rule in this whole issue is likely going to make its way up the Supreme Court once again sooner than we expected. Now, if you're not aware what this lawsuit entails, this is a lawsuit by GOA against the ATF because of the ATF's new rule on unfinished frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80%ers or polymer 80s. Under this new rule, 80%ers are treated to actually be firearms. This new rule went into the regulatory definition of what a firearm is and changed the definition through a web of references to now include 80%ers into the actual definition of what is a firearm. Since 80%ers are now considered to actually be firearms, they are now subject to serialization requirements and then also background checks. And it is this rule that GOA in the 17 states was challenging in the Morehouse case. This case was filed in the North Dakota District Court, and GOA requested that the district court judge grant a motion for a preliminary injunction to stop the ATF from enforcing the new rule, which was set originally to go into effect on August 24th of 2022. A preliminary injunction is simply a request for an order from a court, essentially prohibiting an action, and it seeks to preserve the status quo while the underlying court case is being decided by that court. However, on review, District Court Judge Peter Wilt found that under Bruen and other concepts, an injunction was not warranted in this case. He stated in his original decision that the court believes the ATF's response to the Second Amendment concerns brought up during the notice and comment period to the notice of proposed rulemaking was sufficient. As noted in the final rule, concerns regarding constitutionality of the proposed rule were raised by multiple commenters. The ATF appropriately responded by indicating its belief that the proposed rule was consistent with the Second Amendment's jurisprudence at the time the final rule was drafted and explained why. It is difficult to fathom what more the ATF could have said in response at the time, as it could not have predicted the future development in the law. So the judge in the case believed that the Bruen decision does not impact the ATF's new rule, since during the notice and comment period, the ATF made claims and responses to why they believed the Second Amendment is not implicated at that time. The judge essentially gave the ATF a pass that Bruen came out essentially after the drafted proposed rule and after they finalized the rule. But keep in mind, the Bruen decision was released a month before the finalized rule, before the ATF published that rule. So that to me was a little bit confusing of why he gave the ATF a pass. Another concerning thing that the judge did was he tried to cabin the Bruen decision as something that only impacts proper cause standards and concealed carry permits. He says this issue, in contrast, is about commercial sales, and therefore it does not infringe on any individual's right to keep and bear arms or any business's ability to manufacture a firearm for personal use. So again, he tried to cabin the Bruen decision to only applying to concealed carry and then said it did not apply to this specific situation. After the denial of the preliminary injunction, GOA appealed that decision up to the 8th Circuit. The 3-judge panel that reviewed that issue were Judges Stephen Colton, Michael Meloy, and then Raymond Gruender. On review, the 3 judges unanimously agreed that the lower court was correct in denying the injunction and that the ATF's frames and receivers rule should not be halted. In their decision, that 3-judge panel in the 8th Circuit primarily focused on the fact that they believed the plaintiffs cannot show that the ATF rule will cause irreparable harm. To get a preliminary injunction, a party must show 4 main things. First, a likelihood of success on the merits. Second, irreparable harm in absence of that preliminary relief. Third, that the balance of equities tips in their favor. And 4, that an injunction is in the public's best interest. In reaching their decision, the 8th Circuit 3-judge panel found that GOA and the states could not show irreparable harm. The 8th Circuit stated that, "We find that the plaintiffs have failed to show they will suffer irreparable harm absent a preliminary injunction. We need not address the likelihood of success on the merits." They go on to say this is especially true when, as is the case here, we are not the only court addressing the merits of these arguments. One of the key things that the 8th Circuit 3-judge panel is doing there in that decision is essentially they're avoiding looking at the likelihood of success on the merits factor, which is the biggest factor of the analysis. Instead, they looked narrowly at irreparable harm. In the order, they essentially deferred to the 5th Circuit's upcoming analysis of the likelihood of success on the merits and this challenge to the ATF frames and receivers rule. Remember that we have another case called the Vanderstock v. Garland case, which is currently actually waiting for a merits decision out of the 5th Circuit Court of Appeals. It's in front of a 3-judge panel. So recently, the 8th Circuit decided to punt on the ATF frames and receivers rule. They said that there was no irreparable harm. They're not going to decide likelihood of success on the merits, and instead they're going to leave it to the 5th Circuit to review that issue. And kind of this was all done in a flippant 10-page decision, so they really didn't give it a ton of analysis to even reach that unanimous decision. Now, in response to that decision, GOA filed for en banc panel review. What that means is they went to the next level in the 8th Circuit. GOA wanted en banc panel review, and they wanted the en banc panel to grant review to the case and determine whether or not the lower court should have in fact granted their preliminary injunction. Well, we received an order from that en banc panel in the 8th Circuit, and they have denied en banc panel rehearing. So they have denied review to this case. So even the highest level of the 8th Circuit does not want to address this issue right now. But there is kind of a slight silver lining that I want to mention. The fact that the 8th Circuit has denied en banc panel rehearing means that GOA, if they want, can now file for Supreme Court review. They could, if they wanted to, file for a writ of cert to the Supreme Court or a writ of certiorari. I haven't spoken with GOA's attorneys, but I suspect that that might be something they want to look into, might be something that they're considering. The recent denial probably fast-tracked that option by another year or so, because if you're bypassing en banc panel review, essentially you're skipping about a year and a half worth of process in the 8th Circuit. Despite all that, I still have some hesitations with this specific case. First is the fact that the Supreme Court does not like to review cases on an interlocutory basis. That essentially means that the lower court never issued a final merits decision in this case. Instead, this is just on a preliminary injunction, and oftentimes the Supreme Court does not like to review those types of issues. Secondly is the fact that the Supreme Court has already granted stays to the ATF in their favor in the Vanderstock frames and receivers case, which came out of the 5th Circuit. This is something we've covered extensively on the channel, but you may recall that recently, actually twice now, the Supreme Court has granted the ATF's request for a stay and has blocked the lower court's decisions. The first one that the lower court granted was a nationwide vacatur. Then the Supreme Court stepped in, stayed that decision, and then the lower court issued a more limited injunction which only protected specific companies. And then once again, the ATF went to the Supreme Court, requested a stay, and the Supreme Court granted that stay in favor of the ATF. So twice the Supreme Court has stepped in on this issue and has ruled in favor of the ATF. In my eyes, the current sentiment of the Supreme Court seems to be that they are not in favor of injunctions which would temporarily halt the frames and receivers rule. The third thing, I think, is the fact that Morehouse in that case kind of has something going against it, and it is that very decision out of the 5th Circuit, the Vanderstock decision, which is currently pending. The 5th Circuit Court of Appeals has heard oral arguments at a 3-judge panel level in the Vanderstock case, and that's an actual merits decision. So if the Supreme Court wants to take a case up for review, which deals with the ATS frames and receivers rule, the Vanderstock case is a better candidate because it's a merits decision, in contrast to what's going on in Morehouse, which is still in an injunction interlocutory posture. So that's the current update in the battles against the ATS frames and receivers rule. The 8th Circuit en banc panel has denied review of the case, which is likely setting the stage for a new request to the Supreme Court and a new battle in the Supreme Court. I'm not confident right now that the Supreme Court wants to get involved in this case and this specific issue, but we will have to wait and see. If I get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also, I want to mention that if you're a longtime viewer of the channel and maybe you've watched multiple videos and you're not subscribed to the channel, which is about 60% of all my viewers are not subscribed to the channel, please consider subscribing to the channel, help the channel to grow, and help to spread this type of 2A information to more people. But regardless, thank you guys so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.